Thank you, everybody. I'm Brad Sherman from the University of Queensland, and I'd like to welcome you to the first in the ISHTIP seminar series. And it's my great pleasure to host it tonight, and also particularly to welcome Hyo. I think it's particularly fitting that she gives the first talk, given her position within the and her role and her influence in the field. I'd like to begin by acknowledging the traditional owners, the Turrbal and Yagara people of the land in which I come, and also the owners in which you are located. I'd also like to thank Shruti for her help, who's co-convening this with me. Today's presentation is the first of 6. Our plan is 3 before the end of the year, and then 3 before the next ISHTIP conference, and we'll repeat the pattern next year if all goes well. Tonight's seminar, Hyo will speak for 30 minutes or so, and we're followed by questions. And if you have any questions, please put them in chat or put your hand up and we can ask them after. So hand over to Hyo. Seminar title is After Patent Regime. Thank you. Oh, sorry, one last thing before I forget. This seminar is being recorded as well. Thank you.
Yeah, so thank you so much for Brad, Carol, and Shruti for enabling the ISHTIP online seminar series. We're profoundly grateful for your help in doing so. Before I start out with the substantive presentation, though, I do want to say that we have a date for our annual workshop, which will be in June next year in Sao Paulo, Brazil. So the save the date email will be circulated very soon. This is entirely my fault, not my co-director Gabrielle's. So hopefully you should find the save the date emails with the workshop dates in your email inboxes soon. So I'm going to share the presentation now. Let's see. Can you see it okay? Yeah. Can everyone see the presentation?
That's good, thanks.
Yeah, okay. So this talk is really, and actually I didn't want to go first. It just has so happened that the possible dates that was suitable was just happened to be the first seminar slot. So I actually didn't want to go first, but it's fine. But also this is to say that this talk is about a question that I've been grappling with and talking with friends and colleagues about since I think the beginning of the COVID pandemic, but in much more intensified form since the beginning of the second Trump administration at the beginning of this year. And one of the questions that that was really preoccupying me was to what degree we can make sense of what is happening right now politically, and in terms of the changes being pushed through the global trading patterns as we have known it since WTO, to what degree these kind of changes affect or have any kind of effect on patent law. And I think we saw the last big controversy around the political significance of patent law during the COVID pandemic in the so-called TRIPS waiver debate. And then I think after the kind of non-event of the so-called TRIPS waiver decision, things have quietened down, but they haven't really, because we have a lot of other political events to process and to digest. So this is one attempt to make sense of what is happening. So I wanted to start out with Mario Biagioli's article, which I think many people know. It's been quite seminal since it came out in the field of patent law theory. And there he argues that the development of modern patent law, especially its very seemingly technical requirement of bureaucracy, interpretation of what is required. So there are substantive doctrines as well as procedural requirements that actually they are very much rooted in political theory. So the modern patent law is doctrinal administrative development, which is embodied in the idea of so-called patent bargain, has to be regarded together with changes in polity. So the form of organization of politics is very much closely related to the legal development, not just at a broad ideological level, but very much in its mundane bureaucratic details. So that kind of link that the changes in polity are related to legal changes, I think is one starting point to look at it. And what I'm looking, and I thought it's helpful because I'm thinking about, okay, so what is changing now politically? Does that mean that, or does that imply rather, that we might also see some changes in law? And if we don't, then where do we actually end up? So it's a kind of a diagnostic, I guess, strategy to take one article and the claims that it makes in order to assess and to diagnose what is happening now or not happening now. Then I wanted to add some perspective about the idea of patent republic. So as I was thinking, I realized maybe there wasn't a patent republic to start out with, and it's a theoretical justification. And it's one way to make sense of the legal changes as they have occurred after the late 18th century. But I think in the meantime, we have had a lot of interesting scholarship that were critical of the idea of inventorship equaling citizenship. Then I want to go on and problematize the missing notion of the public. So in the patent bargain, we have the notion of the public, and on the other hand, the limited monopoly right, and talk about that, what that actually means in terms of moving from the national level to the international level, and the implied idea of a republic and also democracy. Want to introduce some critical political economic perspectives into whether we ever had patent republic and what is actually happening now. And then really kind of open up the discussion to, I guess, if there's a missing notion of the public at the international, transnational state, and we are returning at the moment to nationalist policy making, including where the state acts like a capitalist actor. I'm wondering, is this really a new development, or are we returning quasi to 1883? The 1883 was the signing of the Paris Convention for Industrial Property. So this is the rough kind of direction into which I want to take the discussion. So let's start out with Mario's argument in the 2006 article, Patent Republic. And there he writes, the transformation of the subjects of political absolutism into a politically sovereign public set the conditions of possibility of the patent bargain, the contract between inventors and citizens. At the same time, it was the introduction of patent specifications that made the contract politically defensible by distancing it from the odious monopolies of the Ancien Régime. So I think still the strongest or the most prevalent justification for patents that we see in public discourse is that patent law is a regulatory tool, it's an economic policy tool, despite all of the natural property law rhetoric that we might encounter. But I think the economic policy tool is very much kind of always being mentioned as if we wouldn't have patents, there would be no reward for the inventor, and there would be no progress, no innovation. So that's because of the enabling disclosure of inventive information. And I think a lot of us actually have researched how the disclosure requirement is insufficient, that the inventive information disclosed is very much of a legal nature. It doesn't necessarily have to correspond one-to-one to scientific information. So we've done all that. But the rationales are still being uttered, and patent information is seen to have, well, to have value in the sense of as either indicating some kind of trends, some people take it as an indicator of inventive activity, of progress, innovation, and so on. But I think the big interest for me here is that the patent bargain is in public interest. The question really, though, is, was there ever a patent republic? And I think when we go back to Mario's definition of the patent bargain being a contract between the inventors and citizens, the idea of citizen and the idea of the inventor were very much interlinked. So whoever were not actually really recognized as citizens suffered as being recognized as an inventor. And I think we've had some really interesting scholarship coming out in the last 3 to 4 years. And I just listed some that I could think of immediately. So articles by Kara Swanson, by Jessica Lay, who wrote a book on patent law and women, and Jenny Bulstrode, who is a historian of science, who wrote about Black metallurgists and the making of industrial revolution in the British colonial context. So already I think the patent bargain seems to be something that is very much premised on the liberal idea of citizenship imbued by rights without much regard for what has actually happened. So the public then, which is supposed to be benefiting from the patent bargain overall, seems to be oscillating between being defined as rights of individuals, as property rights holders, as patent holders, as well as nationalist interests. And it's this kind of slippage or quite badly defined overlap that I find interesting. So when you look at like actually who is actually getting a lot of the intellectual property income, and that in very, very simplified terms, we might talk about IP capital rich countries and IP renting countries. So one way I think about it is like how much license income a nation gets on the basis of the IP it holds. And this is a little bit dated, the data, but in 2021, which was in the midst of, I guess, the waiver discussion, what's interesting is to see how the IP receipts overall in the world have really skyrocketed since roughly 2000. Well, I think historically it makes a lot of sense because we had the coming into force of TRIPS. But when you look at where it really, really explodes is like once around, mid 20, so around 2015, and a little dip in 2020 with the breakout of the COVID-19 pandemic, and then it goes up exponentially again. And Germany has very much exponentially increased its IP receipts since 2020. Now I was looking at that because Germany was one of the most vocal opponents of the TRIPS waiver proposal. Then when I looked at actually who was actually in deficit or who was in surplus of IP income, you can see very much in clear terms, and this is interesting, right? In the context of the current discourse around who's free riding on who and who is engaged in exploitative trade practices and who isn't. So you see the blue bars are exports and the red bars are imports. So imports meaning that you are licensing IP in and you pay for it. The exports are where you license IP out and you receive income. Then the balance is the surplus or rather the differential between exports and imports. So you can see the US, for example, in terms of the charges it receives for its US held IP being used has a very, very large balance there. It receives way more in IP income. And what's interesting there, China, as you know, which is routinely being accused of of IP breaches, the balance is pretty negative. The same thing with Brazil, India, South Africa, Korea. So, like roughly speaking, in very rough terms, the countries that benefit most from IP capital is UK, Germany, Japan, and US. Now, this is interesting, right? Because when we go back to 1883 to the Paris Convention, there is no mention of public or public interest. This is really about the protection of individual inventors across different jurisdictions. It's about the equal treatment of individual national inventors. There is no mention of the public, but at the same time, I mean, there are also other WIPO statistics which show which ones are the heaviest patent users, and they're all typically very, very large, well-known corporations, especially in the tech field. So there's this strange slippage between going from the equal treatment of individual inventors to statistics that are being produced at the national level. I mean, of course, that might be nationality or but as we know, I mean, things are much more complicated because the multinational corporations, they have their seat in one place for tax reasons, but then the production happens elsewhere, sales happen across the globe. So that multi-level complexity is not really being accounted for in patent law texts, at least. So when we expand the patent, I guess, bargaining narrative justification from the national level to the transnational level, it becomes really hard to maintain or to justify because the patent bargain was originally in a Republican domestic context, right? And of course, at that time, especially in the 19th century, it wasn't just about domestic interests. It was about like actively encouraging other people to get out and either benefit from learning from other jurisdictions and then bring it in and then patent. But then I guess the international system was designed precisely to prevent that. But at the transnational level, it becomes really, really difficult because the same law to different degrees with different, I guess, discretionary policy spaces that are not really being used for other reasons, assumes that there's a trickle down or a trickle across benefit of patent law for the public good, but there is obviously no notion of global public or global public good. It becomes even more complicated when there's a blurring of public and private divide, especially when the public body of the government or the state acts like a joint venture capitalist without a return on investment. And then there should be a question mark rather than a colon. Another problem is also if the state does not act in the public's interest, be it its own national public or international public, then to what degree is patent bargain still valid? So this is a slide where I just try to literally just write down everything that I could think about this strange political moment right now. And I presented some of these ideas in an earlier History of Science and IP Summer School in Geneva, but I want to just briefly just talk about it again because at this moment, it seems to me that there is such a discrepancy between patent law rhetoric and the reality of patent law practice, which at the same time are somehow linked and related to the political changes that are going on. So this was just my attempt to map out the the situation as I see it right now, especially now that we have critics of the IP law system, not just coming from the traditional left, so being concerned about access to medicine or access to knowledge, which were traditionally left concerns. And now we've got critics of IP law generally as a whole system coming from the right. So people like Elon Musk, Jack Dorsey, the founder of Twitter, the problems with IP law. Now, whether they really mean it or whether it's a rhetorical strategy, that remains to be seen, but it's very much tied to, I guess, their interests in so-called AI technology. But just to give you a brief rundown of what I think we should be clear about is especially the upper half. The lower half, like actually there should be another line going through here. But the upper half is really what we just talked about, is that we have the ideology or the theoretical underpinning of modern IP law, which is based on liberal individualism, but the reality is very different. The labor theory of value, which says that the person who expends her labor should be rewarded with a property right as a natural right or even as a reward. The reality is that labor yields less returns than capital does generally, but especially in IP, because a lot of times the laborer or the inventor is not really the patent holder. IP is very much used as a speculative asset or as a rent vehicle for licensing values, but or also strategic value or sign of credit and creditworthiness. There is an underlying and pervasive and really annoying rhetoric of innovation without really asking who innovation benefits or innovation for who, which is equated very problematically with inventions. So there are a lot of useless inventions. Large majority of them are useless, but there are some very valuable inventions that are patented. And I think the economic research at the moment is inconclusive about whether patents really incentivize or result in innovation or not. It depends very much on the sector and the stage of technological development in different fields. So I guess where we are right now is as I see it, quite depressingly. It's an era of nationalism first. It's about quite open imperialism. Various systems of international laws have been failing much more transparently than before. So there's not even the need for lip service to certain kind of legal norms. People have argued that we are in a new neo-mercantilist era. People have also said we're in a new polycentric era where the global dominance of US is shifting to a more multipolar global, I wouldn't say order, global situation. Now, all that is going on as some people have argued, like Morozov, that we are entering or we have entered the techno-feudal era, where very, very essential infrastructural technology is being owned by few. And it's very, very hard to escape it because the rules are not being set democratically. So this is the landscape. And I want to go back to Mario Biagioli's, well, it's a table in the Patent Republic piece where he tries to really kind of, very schematically list down the differences between the absolutist era where early privileges were granted patents as early privileges, and then the modern patent, what he would, in shorthand describe as patent republic. And I was looking at the table and thinking, like some of the categories, well, some of the statements are still very much valid, such as patent protection has been growing globally. So these are just factual, kind of legal factual descriptions. Novelty is defined in terms of chronological priority, novelty requirements global. So these are all, like some of these things still hold, which very much seem to relate to the patent bureaucratic procedure. But the other statements are just don't hold up, such as patents are rights of citizens. I think it'd be really hard to argue these days that patents are rights of citizens. I mean, it's just a fact. You can go to WIPO or to OECD databases. It's very rare to see an individual is the patent holder. A lot of individuals obviously are inventors, but they're not necessarily the patent holders. Patents are contracts between inventor and the public. I wouldn't think that statement holds. Um, Inventor's author doesn't hold either. I mean, typically you would need a patent agent or lawyers. So there are a lot of, or representation, presentation to representation. Really difficult to say if a patent document represents anything or anyone. What does it really represent except the boundaries of the patent right? And some kind of a legal description of an invention. So now how do I move forward? There we go. So I want to conclude the discussion by just kind of going through some of the points that I'm still thinking through, struggling with, going back and forth on. So there are about 5 of them. I think the Republican ideals that we teach our students, we say, okay, so there are like, roughly 4 types of patent justification. If we go back to the Macklem and Penrose article, and then you say, oh, you have the natural law, then you have reward, you have incentive, and then the disclosure function as part of the patent bargain. So if just that, there's the liberal individual citizen as patent owner, I don't think we can really hold that up anymore. That was the ideal, but like a lot of other things happened in between. The idea of the republic, which I think in Mario's article is necessarily a democratic one, like how do they apply to international and transnational levels? I think it kind of goes back to the criticism of the WTO as an anti-democratic institution as we've known it since, at least in Seattle. But when you think about it, non-democratic polities in nation states were never an issue for TRIPS. I guess Paris Convention, we don't even need to problematize in that way all that much. But I think at least for the TRIPS, when we think about it, I mean, Russia is part of TRIPS, WTO, China is. So the actual political organization of a member state in WTO doesn't matter all that much, with the implications that it then gives to the legitimacy of patent law being enforced as part of TRIPS. So then I thought about, okay, so national interests are being advanced through their corporations, their national champions. And then I thought, is this really new? Isn't this just a return to mercantilism and imperialism? So when we think about the British India Company, for example, nothing new, right? So the implication of that then would be that we are moving from the individual in the original patent law narrative to corporations in the patent bargain, and then corporations being, I guess, having their own legal personhood. So I think that's something that has been really under theorized, which would really need much more thinking. And then I think thinking about the role of patent law generally in the current era where tariffs and trade dominate many headlines. For me, the question is, will patent law matter all that much? This is because, and again, this is not a new question, right? I mean, we had the interplay between patent law and trade practices in the 19th century. But what might be new now? well, I think it will depend on like what travels where. So in terms of the goods and services, rather than having actual commodities, physical commodities being transported back and forth, and this will be much more playing out. Like, I mean, the current situation will be playing out much more at the level of service, and digital service in particular. So goods like platforms, different kind of, I guess, hardware needed to power these platforms and databases and batteries. So I think we will see that kind of I think we will see the tariffs mattering all that much, because if the tariffs are so high that you can't actually access a market anyway, then patents don't really matter all that much. So in that sense, I feel like currently the tariff politics really trump literally patent strategic considerations. But I might be wrong there. I'd be really curious what people think about this. Um, and then uh, what does it mean that the states are openly state capitalist? And and differently from the 19th century or the late 19th century, we do have the TRIPS era, the TRIPS agreement, and regardless of whether it will be enforced or not, it has set into place a certain kind of motion, such as that the national courts will need to, well, the national courts will be responsible for addressing patent infringement or I mean, it will be just something that is not just down to bilateral agreements, for example. And so what's really new here? It seems that together with the trade pressures and the political power of trade sanctions, as we're currently seeing in relation to US and Brazil, for example, individual corporations will still take advantage of the patent law regime. So they will continue to file their patents in different jurisdictions, try to hinder generics to come to the market, for example. So they will, if they have the financial power, they will litigate abroad. And only those who have the financial power will do so, together with the political power that backs them up, if needed, such as what is happening in the US-Brazil context right now. So the opening of the special 301 investigation on Brazil, which also has an IP component to it. So this is pretty much what I have to say. And I'd be really curious what people think. So thank you very much.